overtime segment, we are privileged to have one of Florida's finest criminal defense attorneys to my left, Anthony Rickman from the Rickman Law Firm. This is the guy we want to talk to on two laws that are going to break. Number one, Anthony, we appreciate you being here, and we want to jump right into this, which is Florida's new DUI laws. A lot of stuff have hit social media. A lot of things came out. Garrett and I were reviewing it, and we thought of one name, Anthony Rickman, to walk us through to say, hey, when I look at this, I look at two things. One, that the law coming out of a place that you had said off camera that, hey, I think there was a lot of public support where this would have come from. Talk to me about that first, then let's kick around where the rubber meets the road on this.
They passed a law that makes more severe penalties for multi-DUI offenders who go out and drive and kill somebody. So basically what the legislature did is they got together and they said, we need harsher punishments for people who are convicted of DUI manslaughter or BUI manslaughter who have prior DUIs. Previously, it was a maximum of 15 years, second-degree felony. The legislature increased that penalty to 30 years, now making it a first-degree felony.
Gee, I think that makes sense, right? From the public support, public policy standpoint, second offenders, we don't have a lot of forgiveness for somebody, especially when we're talking about a manslaughter charge.
Exactly. Yeah, that's what I was going to say. I think, in that case where the harm that you're doing, people want to see the correlation with the punishment for that. So, yeah, it makes...
Now, and my non-expert opinion, that's why we have Anthony Rickman here, let's call it an expert opinion anyway, is what I don't like, Anthony, is the second part of this law. Let me back up, Luke, for a second. When Anthony and I started out as prosecutors together some 20 years ago, their refusal to submit to a breathalyzer test was a civil infraction. And for the public, what were we talking about here, Anthony? We're talking about then you sign up for your license. It says that if you refuse to take a breathalyzer during a DUI investigation or a DUI stop, you would lose your right to have that driver's license for a year, but it was a civil penalty. Guys like Anthony and his team of lawyers, what they could do is apply for hardship licenses, allow people to drive to church, school, and or work to make income. But this statute, this change in the law has now turned it on its head and has done what, Anthony? Walk me through it.
So look, back in our old days, you refuse, and a first refusal, you take that license, you take those keys, and throw them in the garbage.
This is literally what he would tell the jury when we were in there.
And I also would slam them in the garbage too.
And it was very effective. But now, all of a sudden, the fun and games is over with that.
It's over. Now you're going to jail. Don't pass go, don't collect $200. You're looking at 60 days in jail if you refuse to submit to a breath test. So now somebody arrested, pulled over for DUI, who does field sobriety exercises, they do well. This officer says, hey, I want you to come into my machine, give me a breath sample of this machine that they've heard really bad things about, that malfunctions, that you don't trust. And if you say no, you're looking at a misdemeanor in and of itself. A new crime has been created for a first refusal. And it doesn't just apply to first refusal of breath. Let's say that officer is out there. You're drunk. You're wasted. I smell alcohol. And you know you're not. Right? And you still get arrested because you can't bad balance. You go to the jail and you blow triple zeros. And he says, all right, I'm not going to take off those handcuffs. I don't unarrest you. He hands you a little cup and he says, go in the bathroom and I want your urine sample. And if you refuse that urine sample, even if you're under the legal limit on a breath test, you could still be charged with refusal to submit to a urine sample. So now we have a whole new type of crime created based upon someone refusing to incriminate themselves.
Think about that for a second, G. Now what we're talking about is not the good old days. Garrett, also former prosecutor out of Miami-Dade, hundreds and hundreds of DUI cases. Back in the day, sometimes criminal defense attorneys, and I'm not saying Anthony would or we would advise, but a lot of times it was known as a double refusal. If you got stopped, don't participate in field sobriety exercises and don't participate in a breathalyzer test voluntarily. And why is that? Because we'd be handing evidence to the prosecutor. A lot of criminal defense attorneys would say, hey, take your lumps. Let me investigate the probable cause if it was even there for you to get stopped anyway. And we'll work through the license suspension, which sometimes can even be shortened down to a couple months. But now, G, this is where I start thinking, are we at an overreach position where all of a sudden our civil liberties being impacted here? I don't like what I call the duress argument of saying, you have to do this or I'm going to charge you. They want me to give you evidence. I don't know, man. Is the law going too far here? Talk to me. What does appellate courts, what's the Supreme Court usually say about these things? How far can they go?
Yeah, so people can have those arguments, and they still do. I think there was even dissents within the United States Supreme Court case where they said that you can create criminal penalties for refusing to submit to a breathalyzer test. It's different for blood and stuff. I'm not sure about the urine thing, but that was interesting. I didn't think about that, what Anthony had said. But yeah, because they're trying to balance, unreasonable searches and seizures. And so the Supreme Court has said it's not really unreasonable to have you give your breath, to try to protect that against the government interests of protecting society and having people running around driving intoxicated. So they're trying to do the balance. And so they kind of landed the Supreme Court saying, breathalyzer, it's okay to criminalize a refusal, but not for blood. You still need to get the whole search warrant and have probable cause and everything like that. So there's differences of opinion on this in the highest court in the land. So it could go, either way.
Yeah. So look, second refusal has always been the crime in the state of Florida, at least as long as we've been practicing. And the courts really have addressed this matter in the realm of a second refusal. And what the courts have said is that it's your right to remain silent or your right to an attorney has nothing to do with your refusal to submit to breath test. And the rationale is that when you get your Florida driver's license, you have already agreed. It's called implied consent. You've already given them consent to submit to any and all chemical tests to determine the alcohol content of your blood or of your breath. So in this circumstance, you've already consented.
And what the state of Florida is saying is if you breach that contract with us, we now get to do what?
We could take your license, but the question is, can we charge you criminally?
Boom. And that's where my issue. Look, I'm the biggest proponent of DUI laws, safety, 100%. You know me as a former prosecutor, I was a hard liner. But I get nervous when I hear coercion, duress. People, when they get stopped, are already scared of the bejesus. They don't know what's going on. Number two, it's not illegal in the state of Florida to drink alcohol and drive. It's only illegal to get that in impairment, can't be impaired. But you're telling me that we're going to rely on law enforcement discretion to then say you could be not DUI across the board in my refusal to submit, and maybe I had 2 Bud Lights at dinner watching the game, and I'm nervous and I don't submit, I just get hit with a misdemeanor, G?
Well, it's a little tricky because you have to actually be under arrest first before they have you do the breathalyzer. So they can't just pull you over, smell alcohol, and be like, oh, I want to see what you have, what you're going to blow, and then I'm going to decide to arrest. So I'm coercing you. They already have to go through a process where we have reasonable suspicion, probable cause. I saw him fail the exercise.
We think you're there.
And all that. So that kind of takes away a little bit from maybe some of the duress to be like, oh my God, what am I going to do? You're already under arrest at that point.
But they don't unarrest you. You blow over the limit. They don't take off those handcuffs.
Right.
And the thing is, when you have somebody making that decision, and really what I think the bigger chilling effect is that what is it going to do to a defendant who wants his right to a trial? When I can beat this DUI. I'm not impaired. My client looks great on this video. They do the walk and turn, the one leg stand, the finger to nose, everything. Right. Look like Baryshnikov doing the exercises. Yeah. But because he felt that this officer unlawfully charged and arrested him, he doesn't feel comfortable blowing into his magic box. Okay? Now you're going to have a secondary crime.
Reminds me of the case, I don't know if you and I were the prosecutors on it, but there was a cheerleader at Halloween. It comes to our desk. The state filed charges. I look at the field sobriety exercises. Well, the Halloween costume, she was a freaking USF cheerleader. You know what she did on her field sobriety? She said, oh yeah? She busts out a back handspring and a backflip. Now, under that scenario, the officer who was already pissed arrested her. Yeah. Now, if she would refuse to then do the breathalyzer, she'd be charged again. We would get the case as a good prosecutor. We'd say, look, the evidence are there. We're dropping the underlying DUI, but now your refusal's there.
But I think there has to be some sort of prosecutorial discretion and prosecutorial responsibility. Mm-hmm. And when a prosecutor analyzes these cases and they look at them and they say, hey, look, somebody was arrested for a DUI. We don't have it. Are we really going to now punish them and prosecute them for not giving the breath test? I think really that's where it comes into the state attorney's office to see how they are going to handle. And really, this is so new. We haven't really seen what they're going to do in my world. The state attorney's office offers certain programs. One called in Hillsborough County called the Rider Program, where essentially you get your automatic reckless driving. You jump through a whole bunch of hoops on the DUI, but now what happened? And you get your DUI reduced to a reckless. You get your withhold. So you're not convicted. You can seal your record. But what happens to the refusal? It's a crime in and of itself.
Garrett Walshhammer gave to me was the argument of a disproportionate punishment, which was opponents are going to say it's too harsh by the act itself because the act of refusing doesn't involve any harm, and it's not in of itself proof of intoxication.
Yeah, and I think it kind of goes with Anthony was just saying. It's almost like a double jeopardy situation. We can get you on one or the other. Even if you're not guilty of the first one, we got you on the second one, even though the original reason why we got you was not even valid. So, yeah, it kind of puts the person in a catch-22. No question. I was wondering how our defense attorney is going to challenge that. Do you have to go back to just like the stop at that point and say there's no reasonable suspicion even after the field sobriety? They shouldn't have ever asked for a breathalyzer? Or how does that work?
Actually, one of the comments we got on social media instantly when we told him you were coming on, the first thing that we popped up was a comment that says, how is a criminal defense attorney even going to be able to defend against the refusal?
Look, I defend against it by saying there was no probable cause to make the arrest in the first place.
Going back to what Garrett
Now we
said.
talk about the stop, we talk about the traffic infraction. We don't get to the refusal, but for the violation of someone's Fourth Amendment rights against a search and seizure on a traffic stop, an arrest, a detention is a seizure. So we fight it with probable cause. The problem we have with that is that the case law is really bad for defense attorneys. Odor, red bloodshot glassy eyes, unstated sense of
Distinct
speech,
odor of an alcoholic
slurred
beverage emitting
speech.
from the respondent's breath.
That's enough.
How many affidavits have we seen that say
I can tell you every one of them, every single affidavit. Smell distinct odor, even if they're below triple zeros.
Yeah.
So at the end of the day, we can attack it on those grounds, and we probably won't be successful because the threshold is just so low to make that probable cause determination.
And then it kind of scares me a little bit. Reminds me of the movie with Denzel Washington in Israel, where he talks about there's sometimes an innocent reason to refuse, whether it's fear. So now is it this fear and the power shift where now the state can try to leverage defense attorneys to say, hey, you're going to have to reach a plea on count one for us to let go of count two. So maybe now you got an iffy DUI that a great skilled criminal defense attorney like Anthony Rickman can win in court, but he can't beat the refusal. So do they leverage more power from the state that says, I'll tell you what, one of these two is going to go away if you want to reach a deal. And if not, by the way, if we get you on one of these two, we're going to hammer you on the max, which adds, like you said, another 60 days, a suspension of a year. And all of a sudden now, again, why do 95% of all cases plea out? Because of the threat of over prosecution.
And look, I've seen it since I started practicing on the defense side, is that they use that second refusal as leverage. And that's a year possibility of jail. Now here we're looking at 60 days, and the judges have discretion too. You may be a circumstance where a judge has to convict you on the law, but the judge doesn't have to give you 60 days. So it's not a 60-day mandatory sentence. It's a 60-day maximum sentence. However, they come with probation. The judge can stack you up with a whole bunch of probation conditions. So,
and how many clients do you know that says, hey, if we're offering first-time probation, but if you lose, they're going to try to seek the maximum on the DUI, and hey, by the way, you want to enjoy 60 days, 3 hots in Cotton County? There's not a lot of guys that I know that can be away from the family, the household, the income for 60 days, man.
Well, on top of that, let's say hypothetically you're convicted of a DUI, and you're also convicted of a second refusal. The judge can stack your sentence.
Right.
Your first time,
Consecutive.
your first 90 days on a DUI, and then you're back 60 on the refusal.
Yeah, you're doing 6 months.
That first 90 days, day for day, you don't get gain time or good time. So you're looking at a large sentence, but it could be worse. We could be Texas, where they're sticking needles in people's arms and drawing their blood. And the courts have said that's legal. And what we really see is, does the ends justify the means? They want to stop DUI. They want to combat.
Which we all support.
But at what cost?
There you go.
The cost of liberty, the cost of your right to a fair trial. I mean, the right to remain silent, the right of self-incrimination. And that's the tricky line that we're walking right now with this law.
And let's not forget, I don't think the administrative penalties go away with this.
They don't.
You still have to deal with that part of it, as well as 2 criminal charges. You also have your admin penalties on top of that. So it's a 3-headed monster at that point.
Man, I think Anthony said it best at the beginning. That says this thing was called Trenton's Law, right? Which came effective October 1st of this year. And it was named after Trenton Stewart, an 18-year-old student and football player at a Stetson University who was tragically killed in a car accident back in May of 23. And the driver was impaired and who had a prior conviction for vehicular homicide. I think your point in the beginning of the show made perfect sense. Increasing those maximums for repeat offenders to what Garrett said, we're talking about manslaughter. Absolutely move it to 15 to 30. But what you also said, which was, what they also snuck in here after making this law was they took it a step too far. And sometimes government can do that in a little bit of overreach, Matt.
Yep.
But ultimately, Luke, that's the overtime segment for our legal formation. That's week 9. We couldn't be happier that attorney Anthony Rickman has blessed us with his presence today to do it.
When he gets his first refusal case, let's
Yeah,
bring
hey,
him
this
back.
guy
And see
might
what
be,
happens.
this guy might be making case
Well,
law,
what
like you
happens.
said before. Might see a lot of challenges go up to the appellates. I'm with Garrett. It's going to be a tough mountain to climb. Goes to the Supreme Court where they can do it. I don't think we could look for appellate help here. I don't think we're going to see anybody, Luke, from the state of Florida in terms of Congress, state, Senate, or our governor that would change this after getting in place. So I think it's here to stay.
Yep.